system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
All right, any matters we need to get on the record on behalf of the state at this time?
No, Your Honor. Thank you.
On behalf of the defendant?
No, Your Honor.
Thank you. Mrs. Hartman?
All rise for the jury.
May be seated, ladies and gentlemen. All right, good morning, everyone.
Good morning.
All right. At the conclusion yesterday, you saw that the defense rested their case. The state of Ohio has the option, if they choose to do so, to present a rebuttal case. And in this case, in this trial, the state does wish to present a rebuttal case, and they have a witness. State may call their witness.
Thank you, Your Honor. This time, the state would like to call Seth Stoughton.
Good morning. Please raise your right hand. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, as you shall answer unto God, under the pains and penalties of perjury?
I do.
You may be seated. It's important that you speak into the microphone so that the ladies and gentlemen of the jury can hear. It's also important that you verbally, sometimes it's difficult to interpret.
I understand. Thank you.
So for the record, if you please state your name, spelling your last.
My name is Seth Stoughton, S-T-O-U-G-H-T-O-N.
Thank you. You may inquire.
Thank you. Good morning, Mr. Stoughton.
Good morning.
Tell us a little bit about yourself, please.
I am a law professor at the University of South Carolina, the Joseph F. Rice School of Law, which I'm contractually obligated to call it that. I'm also the faculty director of the Excellence in Policing and Public Safety program at the law school, which is a legislative and grant-funded program that works with police agencies in South Carolina and beyond on collaborative professionalization, providing executive-level training for the most part. I've spent the last 13 years now as an academic studying policing. My focus is primarily on police procedures, tactics, use of force. Prior to becoming an academic and going to law school on that path, I was also a city police officer and an investigator in the state of Florida.
Okay. Let's work our way up from the time that you were a police officer in Florida.
Sure.
When were you a police officer in Florida?
I joined the Tallahassee Police Department in January. I went to the police academy in January and was hired by the police department in March of 2001. I stayed on full-time as an officer until the end of 2005 and spent another 6 months as a part-time or reservist with the agency, so about 5 years.
Okay. So you're, were you mainly in patrol?
Yes, that was my only assignment. I had some additional duties, but my actual assignment was Uniform Patrol Division.
And what does a patrol officer do in Tallahassee?
Probably pretty similar to a patrol officer anywhere. You wear your uniform, you drive a marked police unit, marked police vehicle, and day-to-day interactions are a mix of responding to calls for service. Someone calls the police and they dispatch you to respond, or engaging in what's referred to as self-initiated activity, like doing a traffic stop or getting out to talk with someone.
Okay. And you say you did that for 5 years?
Yes, just under 5 years full-time and an additional 6 months part-time, yes.
After you did that, did you perform any other law enforcement duties?
I switched employers. I went to the Florida Department of Education's Office of Inspector General as an investigator. I was a civilian investigator, so I did not have arrest authority, but I was a criminal investigator, so I investigated crimes as well as administrative issues relating to the Florida Department of Education.
Okay. So you were an investigator for the state of Florida for how long?
Just under 3 years.
Okay. And then what did you do after that, sir?
Then I uprooted from Tallahassee and went to law school. Excuse me.
And now your current duties and responsibilities include teaching?
Yes.
Okay. And where do you teach?
I teach at the University of South Carolina in the law school. I teach in the JD program, so our normal law students. usually criminal law, which is a first semester, first year required class, criminal procedure, which is a Fourth and Fifth Amendment class primarily, and then 2 smaller classes, police law and policy course and a regulation of vice seminar. I also design, develop, and teach in our in the EPS program the courses for police executives.
What is you say you teach Fourth and Fifth Amendment law?
Yes.
What are the Fourth and Fifth Amendments, sir?
The Fourth Amendment is the amendment to the Constitution that governs searches and seizures. It's relevant for law students who are interested particularly in a career in criminal law, prosecution or defense, because it sets out the constitutional limits on when officers can engage in certain investigative activities, when they can detain someone or frisk someone or arrest someone, search someone, or search property like a vehicle or a house or something like that. The Fifth Amendment is a little bit more complicated because there are 5 different rights that are part of the Fifth Amendment, but the one that we focus on is the privilege against self-incrimination, which is also something that police officers have to interact with in the investigative process. That's the Miranda warnings.
So going back to the Fourth Amendment, that has a lot of application with respect to uses of force in policing, is that correct?
It does, yes. Because the Fourth Amendment regulates seizures and because of how the court has defined what counts as a seizure, yes, the Fourth Amendment regulates most uses of force.
Okay. And your executive policing program, did I pronounce that correctly?
Yes, I refer to it as the EPS program because saying excellence in policing and public safety takes too much time.
Okay. And you said you teach executives, right?
Yes. Right now we have 2 cohorts of 16 police executives. Right now they're all from South Carolina, but in this fall we're opening the program up. We'll actually be offering an MSL, a Master's in Studies of Law, focused on public safety executive leadership. So the goal is providing executive level leadership and management skills to public safety professionals.
Right. And I assume you talk about use of force in that curriculum as well, correct?
We do, yes. Actually, January, we're putting the cohort through a critical incident and after action review course that is not specific to use of force, but very heavily implicates how you respond as a police executive to use of force incidents.
Okay. And you say police executive. What is a police executive?
So the term in policing is often command staff level, and we're talking about upper management. Rank and file officers, sort of middle managers, which depending on the agency might be your corporals or sergeants or lieutenants, and then the upper management are the folks who have responsibility for large swaths of police operations. That might be the watch commander who's in charge of an entire shift of patrol officers, or a commander who oversees a particular bureau like the investigative bureau, the entire investigative bureau of a good-sized agency. Exactly what that means and who counts as an executive very much depends on the size of the agency. We have some participants in our program who are from 6-person agencies, so it's the chief and the sergeant and then everybody else. So you can't really go by rank with figuring out who counts as an executive. It's really more about the responsibilities that they have.
Okay. And in addition to teaching at the law school, you also teach at the undergrad, is that correct?
I have taught at the undergrad, but not very frequently. I will occasionally guest lecture in criminology classes, particularly focused on policing. And I've taught at we have an honors college that I've taught a class for before, but it's not a standard part of my teaching duties.
Have you authored any articles regarding use of force?
I have, yes.
Can you tell us about those, please?
Sure. So in addition to teaching, another part of my job is producing academic research. I'm a law professor, which means that I study laws and doctrines, legal rules, and public policy. I describe what I do as basically focused on all of the rules, legal and extra-legal, that we use to get police officers to do what we want them to do and to not do what we don't want them to do, right? So the scope of my study includes constitutional rules, state laws, agency policies, and even informal rules like agency culture or police practices. The articles on use of force, I have a couple of those. Most of them are specific to the Fourth Amendment. Some of them are analyzing state law in either articles or book chapters relating to the use of force. I'm working on another article now about use of force. I have a book that I've written with two co-authors, creatively titled Evaluating Police Uses of Force, that goes through different evaluative frameworks for how we look at use of force incidents.
Okay. And you've testified in use of force cases, correct?
Yes, I have.
You've been recognized as an expert in uses of force?
Yes.
Okay. Have you testified in criminal cases and civil cases?
Yes, I have.
In what areas geographically have you testified?
Oh, boy. Kind of all over. South Carolina, Georgia, here in Ohio, New York, Rhode Island.
Georgia, testified in Georgia?
Georgia, yes. I would have to look. I'm kind of all of California, kind of all over the place.
Okay. And you've testified on the prosecution side, is that correct?
I have, yes.
Okay. Have you testified in cases that have benefited the defense?
Yes, in criminal cases, yes, I have.
That's in criminal cases. Your Honor, at this time, the state moves to have Mr. Stoughton be recognized as a use of force expert.
No objection, Your Honor.
The record shall so reflect.
All right, thank you. Mr. Stoughton, you've been retained to provide your analysis of this case, is that correct?
Yes.
How did that come about?
I think it was early 2001 or mid 2001. I either got a phone call or an email from you or someone in the office.
Oh, in 2001, I was in law school.
I'm sorry, 2021. Wow. I occasionally forget how old I am, and I appreciate you indulging me in that fantasy. In 2021, don't I wish? So it would be early 2021. I got a phone call or an email from someone in your office, probably inquiring as to availability. And then I don't remember specifically, I can't remember which year I am in, but I don't remember specifically, but usually there's a preliminary conversation where we discuss whether the case is within the scope of something that I can analyze.
Okay. And during that preliminary discussion, you get kind of like a rough outline of what the case is about?
Yes, that's correct.
And then you evaluate it and determine if it's something that you want to take on?
Yes, if it's something that I can come to a solid opinion about as an expert, if it's within my wheelhouse, so to speak. Once that's been determined, then I enter into a written agreement and get a bunch of materials and start the process of review.
Okay. Is that what happened in this case, Mr. Stoughton?
Yes, it is.
Professor, how much are you charging? You're getting paid for this, correct?
I am, yes.
How much are you getting paid for this service?
$320 an hour on this contract.
Okay. And how many hours have you spent to date working on this case?
Not including the trip up yesterday and today, I'm hovering right around 35 to 37 hours, I believe.
Is that normal within the type of work you do as a consultant, or is that high or low?
It's pretty normal. Usually for me to review materials and write a report, it very much depends on the complexity of the materials, how many materials there are, how many videos, how many interviews, and the like. Sometimes it's super simple because there's a police report and a video, or there's no video at all, in which case it might be 10 or 12 hours. But I would say my average is 25 to 35 hours through the review process, report drafting process, and then discussing the findings and my conclusions with the attorneys who retain me.
Okay. And you charge for your testimony in trial, correct?
For my time, yes.
Okay. So not for your testimony, not for what you're saying, but for your actual time.
Correct, yes.
What type of items did you review for this case in order to come up with your analysis and conclusions?
There was a lot. So there was a Ohio Bureau of Criminal Investigation investigative report that had a number of exhibits to it. There was at least some documentation from the Columbus Police Department, statements, interviews, body-worn camera video. I have the whole list in my report, but I think that was most of the materials. Looking at the scene, so when there's a particular address, I look at crime scene, well, I always look at the crime scene photos, but I'm particularly interested in trying to learn as much about the scene as I can from crime scene photos. In this case, there was also a scene visit, going and actually seeing the location of the incident. Audio recordings and written statements as well in this case.
Okay. Mr. Stoughton, Professor Stoughton, you have your report in front of you, correct?
I do, yes.
Okay, feel free to reference it if you need to.
Okay. Thank you.
So you indicated that you got, I'm sorry, let me back up. Anything else of significance that you can recall are looking from that list of the things you looked at?
Just to hit the top lines, the BCI investigation, the Columbus Police Department documents, some court documents, dispatch notes, multimedia, including body-worn camera videos, 911 audio, audio recorded interviews, photographs, information from the Upper Arlington Fire Department, and then a range of sort of miscellaneous files and documents as well.
Okay. Did you also review and take in consideration statements made by the defendant?
Yes.
Okay. Those came in two forms to you, a written statement as well as a verbal statement to investigators, is that correct?
Yes.
Okay. How do those statements come about, to your knowledge?
So typically, in the immediate aftermath of an officer-involved shooting, there's a brief statement on scene. It's often referred to as a public safety statement, where someone asks the officer to walk them through the very basics of what happened. And then there's a more formalized investigative statement that's provided, or that can be, it's not always, but it's often provided later. That investigative statement, often when it's provided, comes in the form of a written statement that the officer prepared with a representative or attorney that's submitted to the investigator that may also include an interview. That is, the officer may sit down for an interview and say, here is my written statement, as well as the interview, or it may take the place of the interview, right? It's not uncommon for officers to decline an interview and just provide the written statement that they've worked up.
Okay. And in this case, you were provided a written statement and verbal interview, correct?
Correct.
And just to be clear, Professor, you did not see any testimony from this trial, is that correct?
Yes, that's correct. I've not been exposed to any of the testimony or proceedings in this trial.
So any information that you had came from outside of testimony that's provided, correct?
Correct.
All right. You mentioned BCI. What do you know about BCI? Who was BCI in this case?
In this case specifically, BCI was the entity that conducted the investigation into the shooting. I understand it's an arm of the state attorney general's office, and that it is not uncommon for BCI to engage in this type of investigation.
Okay. So that's normal for an outside agency to look at things when there's an officer-involved shooting?
It's not universal, but yes, it's very normal. It happens sometimes at the discretion of the agency where the shooting happened. They will ask for an outside investigation, but it's pretty common.
Okay. And you came to formulate, after reviewing all of this information, you came to a conclusion, correct, Professor, about whether the defendant was operating within generally recognized police practices?
Yes, I did.
Okay, what is that opinion?
So there are kind of multiple pieces to the opinion. The first is that Mr. Coy's, that it was not consistent with generally accepted police practices or principles in policing to conclude that Mr. Hill was engaged in a burglary in progress. The second relates to the tactical decisions and behaviors leading up to the shooting, which are not consistent with generally accepted police practices in a burglary in progress type situation. That is, if we accept that this is a burglary in progress, Mr. Hill's actions were not consistent with generally accepted police practices that one would expect an officer to engage in a burglary in progress. The third opinion is rather more focused on the actual use of force itself, and my opinion is that the evidence strongly indicates that the decision, Mr. Coy's decision to shoot Mr. Hill, was not consistent with generally accepted police practices, although there is an element of ambiguity in that in that particular context. I can dive more into that in detail. And then there's opinions related to the actions of officers after the shooting, that the failure to render aid to Mr. Hill.
Yep, sustained.
We're not going to talk.
Yes. Excuse us a moment, ladies and gentlemen. State on behalf of the defendant.
No, Your Honor.
Thank you.
All rise for the jury.
You may be seated, ladies and gentlemen. Ladies and gentlemen of the jury, the response to the last question regarding what happened after the shooting is not part of your consideration in this matter and should be disregarded. Okay, you may inquire.
Thank you, Your Honor. Professor, we talk about generally recognized police practices. What are those?
Sure. So generally recognized or generally accepted practices in policing are the standards that we expect, the minimum standards that we expect officers and agencies around the country to meet. It's a little bit complicated in the United States because we have more than 18,000 different agencies, and some specifics can vary very much from agency to agency or state to state or region to region. But when we're talking about generally accepted practices, we're talking about those principles and practices that have bubbled up from the way policing is actually done to the point where you would expect any well-trained, competent officer anywhere in the country to look at that generally accepted practice and say, yeah, that's more or less how we do things.
Okay. As a matter of generally accepted police practices, when can an officer use force?
In policing, it's generally accepted that officers can use force when there is an imminent threat to something that the officer is lawfully trying to do, some lawful objective that the officer is engaged in.
All right. What is an imminent threat, Professor?
Policing has defined three parts to an imminent threat. An imminent threat exists when the individual is reasonably perceived as having the ability to cause whatever threat we're talking about, whatever harm we're talking about. And I'll define these terms in a second, as having the opportunity to cause whatever harm we're concerned of, and as having the intention to cause whatever harm we're talking about. So ability is really the physical capacity to do the thing. If we're thinking about a threat of escape, that is, the officer has a lawful interest in apprehending someone, and we're worried about the person evading apprehension, physical ability would mean the person is physically capable of, for example, running away, which may be the case if they're standing up and generally fit, and may not be the case if they're in leg shackles, for example. And when we're talking about physical ability to hurt an officer, when that's the relevant harm, we're looking again at the person's physical capacity, right? So someone who does not have a knife does not have the physical capacity to stab or slice an officer. Someone who does have a knife does. When we're talking about opportunity, we're talking about whether that threat could occur, whether someone is vulnerable to that threat. So even if someone is capable of running away, if they're sitting on the ground surrounded by officers, they may be physically capable of running away, but they're really not going to be in a position to cause that harm, right? They're not, there's no opportunity for them to do so. When we talk about physical harm again, we can imagine someone with a knife who has the physical ability to stab an officer, but if they're 50 feet away, there's no opportunity at that point for them to do so. Maybe they will be if they're closer, but not at that point. And the last point is apparent intention. That is, looking at the person's behavior, could we reasonably perceive that this person looks like they want to cause whatever this type of harm is? If someone's just standing and interacting with an officer and they could freely run away and they have the physical ability to do so, but they're continuing to just talk with the officer, there's no imminent threat of escape, even though there's physical ability and opportunity. And similarly, if someone has a knife and is within arm's reach of an officer, but they're just cutting up vegetables in the kitchen while they're chatting with the officer, they might have ability and opportunity, but there's no intention to think that that person intends to cause that particular harm. So you need all three elements, ability, opportunity, and intention, to get to the point of having an imminent threat, and that's what justifies a use of force. If you're missing any element, you have what we call in policing risk, and there are other things officers can do to mitigate risk, tactics and communications, for example, but it's not appropriate to use force in the absence of an imminent threat.
Okay, thank you for that answer. You touched on risk. Let's talk about risk for a bit.
Sure.
What is risk again?
Risk is generally defined as the presence of at least one, but not all three elements of an imminent threat. Someone might have the physical ability, but no opportunity or intention to cause a particular harm. Or they might have the intention, but not have the physical ability to cause that particular harm. That's what we would call a risk situation without creating an imminent threat to the officer.
Okay, so if I don't like you and I have in my mind the intent to go punch you, that would be a risk because I'm not in close proximity to punch you. Is that accurate, or am I stating that incorrectly?
No, that's correct. So if you have that intention, if your behavior conveys to me that you have that intention, let's even say you say, I want to punch you, but you're over there and I'm over here, at this point there is no opportunity for you to do so. So there is a risk, but there is no threat that would justify a use of force.
Okay. And you stated it, officers are not allowed to use force when there is a risk.
That's correct, only when there is an imminent threat.
Must an officer be sure that something is going to happen, or wait until something occurs, harm occurs, before they use force?
No, certainly not. If the officer waited until the threat was fully manifested, it might be too late to prevent the harm from occurring, right? You cannot wait for someone to actually fire a gun at you, because if you do, it may be too late to stop them from hitting you with the bullets from that gun. So no, officers don't have to wait until the harm is occurring or imminent, just until there's that threat of that harm. And in the same vein, officers don't have to be 100% sure. They just have to have reasonably concluded that the person has the ability, opportunity, and intention. That allows room for error, so long as that error is professionally appropriate.
Okay. Would that be something like a mistake?
Yes, that's exactly right.
All right, let's talk about a mistake for a bit, Professor. What is a mistake?
I mean, as a simple definition, a mistake is when an officer incorrectly or inaccurately perceives the basic facts of what's going on, or incorrectly or inaccurately comes to a conclusion based on those facts. Simple example, if an officer perceives that someone is walking forward, but they're actually walking backward, that would be a mistake. That would be a factual mistake. And if the officer perceives that someone is walking forward aggressively, but the person is not walking forward aggressively, that would be a characteristic mistake, right? The officer correctly perceives the guy is walking forward, but draws the wrong conclusion from that. Both are simple types of mistakes.
When is an officer justified in using force under a mistake condition?
So long as that mistake is professionally appropriate, and the word that we use in policing is just a reasonable mistake. We don't expect officers, particularly in high-stress situations, to be perfect. We can't. That would be unfair. We don't expect them to perfectly perceive everything that's going on or draw perfect conclusions, perfectly accurate conclusions. But we do expect their perceptions and their conclusions to be professionally appropriate, professionally reasonable.
Okay. So is it accurate to state that a mistake, if it's reasonable, would justify a use of force? A mistake that is unreasonable would not justify a use of force?
Correct, with regard to the mistake about the existence of a threat. If the officer reasonably perceives a threat, those three components, ability and opportunity and intention, if they reasonably perceive that, then that justifies force, even if that reasonable perception was actually a mistaken perception. If they don't reasonably perceive that, then there is no threat and the use of force would be inappropriate.
Professor, talk to the ladies and gentlemen of the jury the difference between a reasonable mistake and an honest mistake.
Objection, Your Honor.
Okay. Excuse us 1 second. Counsel, please approach. Okay, the objection's overruled. You may answer the question.
Thank you, Your Honor. Professor, could you give us a definition or the distinction between a reasonable mistake and an honest mistake, please?
Sure. When we're talking about honest mistakes, we're talking about subjective mistakes, whether the individual in question actually believed the thing that we're talking about. When we're talking about reasonable mistakes, that's not subjective. We're not asking whether the person actually believed it. We're asking whether it was reasonable, whether it was professionally appropriate for them to have believed or not. A simple example from an actual case, when an officer described someone as threateningly holding a golf club up above as if to swing, but there's video footage that shows that never actually happened. You can believe that the officer truly believed, that is, honestly made that mistake about what happened. You don't have to, but let's assume you do, right? You think, okay, the officer is honestly describing what she perceived in that case. But when you look at the objective evidence, you say there's no support for that belief, right? That is an unreasonable mistake, even if it is honest.
Thank you. Going to fear, does fear factor into the equation of an officer being able to use force?
No, not in any direct way. Officers have to manage fear, especially when there is a threat, but just because someone is afraid or experiences fear does not mean that there is an actual imminent threat that justifies the use of force. And vice versa, just because there is an actual threat does not mean that officers are always afraid. They are human, they are perfectly prone to being afraid and feeling fear, but we can't predicate the use of force on the existence of fear or the lack of existence of fear, because that's purely emotional, as opposed to threat being something, being something that we can identify about the world. The particularly fear is internal to the officer. Threat relates to something that the subject or the individual is doing.
Thank you. One last item before we get into further details about this case. What about context? How is context important in these situations, Professor?
Context is really, really important in policing because policing are often operating, officers are often operating in ambiguous situations, right, where we don't exactly know what someone's movement, for example, may signify. We use context or the situation, or what's the phrase that's often used in policing is totality of the circumstances, to help us interpret ambiguous interactions. For example, if officers don't know whether someone is armed or not, the context can help them figure out which direction to lean in on, which direction to conclude in an ambiguous situation. If officers are interacting with an armed bank robber, it may be reasonable to think that an ambiguous action by that person indicates that they are armed. If they're interacting with a jaywalker and they have no other information, it may not be reasonable to conclude that that person's movements indicate that they are armed. It's not, when we talk about threat, and particularly the conclusion of ability and intention, a little bit less so with opportunity, but certainly with ability and intention, it's not just the action, that is the physical movement that the person engages in, that matters. It's the context in which the person is engaged in that movement. For a very, very simple example, you could imagine someone just reaching into a pocket, and the context might change dramatically if the officer says, "Hey, can I see your ID?" and the person reaches into their pocket in response, or if the individual says, "I'm going to shoot you, I have a gun," and reaches into their pocket. The physical action is exactly the same, but what helps us interpret the meaning of that physical action is the context and the totality of those circumstances.
Okay, Professor, I'm going to challenge you here, though. There are situations where jaywalkers shoot police officers without provocation or notice, correct?
Yes, there are.
Okay. Now, would that shooting be, or I'm sorry, would handling jaywalkers be justified to use force against them?
No,
Why not?
because we still have to look at context as what we expect to happen in any given situation. And although officers certainly have been ambushed unexpectedly, that's not a matter of course. That's exceptionally rare. And if we play that logic out a little bit, we can create some really troubling possibilities. For example, we know that officers have been ambushed and killed sometimes, but that doesn't mean that on every scene that an officer drives up to, they would be justified in shooting everyone they see because of the possibility that one of those people might be an ambusher, right? We have to have specific facts that officers can identify and articulate to say, in this case, I believed this person presented this threat, and here is why. And with the jaywalker generally, even though jaywalkers have occasionally hurt officers, we just don't have those facts. With an armed bank robber, on the other hand, we could say, look, based on the specific facts of this interaction and this individual, I have good reason to believe that this guy is armed. And that's not just a generalization of, well, generally bank robbers are more dangerous, right? We don't want officers to rely purely on generalizations because the situations that they engage in are so dynamic and fact dependent that generalizations can be highly misleading in both directions.
Are you familiar with the term use of force continuum?
Yes, I am.
Okay, what is that?
At a basic level, the use of force continuum lays out different types of resistance or threat that officers may experience and different levels or types of force that officers can use. And it basically is typically viewed as a training or policy tool to help communicate to officers the less serious the threat, the less serious force you get to use in response. The more serious the threat, the more serious force you get to use in response.
And that kind of changes depending on the interaction, correct?
Absolutely, yes. Where you are on the use of force continuum depends on the nature and severity of the threat that's presented, and that helps dictate the nature and severity of the force that the officer gets to use in response.
And would it be accurate to say that that can ratchet up or ratchet down depending on the facts of that specific encounter?
Sure. Potentially multiple times in an encounter. An officer may have a very low level of threat initially that would justify maybe no force or very little force. That can escalate up, and it can also escalate right back down again.
Okay. So using your bank robber example, if a bank robber was running out of the bank and then dropped his weapon and put his hands up and said, "I surrender," and got on the ground, that would not necessitate the same use of force. Is that accurate?
Yes, that's correct. Even if the bank robber had previously pointed or even shot at officers, very, very high level of threat that would justify a very high level response. At the point where he visibly disarms himself, puts his hands up in surrender, it's not going to justify the same level of force that was previously justified because the facts have changed. The threat has changed.
You've had an opportunity to review this situation that happened on December 22nd, 2020 with Mr. Coy, is that correct?
Yes.
Okay. Walk the ladies and gentlemen of the jury through your analysis and your conclusion.
Sure. So the basic framework for the analysis is reviewing all of the information, making sure that I understand the basic facts of everything that happened, and then identifying the relevant generally accepted principles or practices in policing that apply to that situation, and then just kind of holding up the officer's decision-making or actions to the generally accepted practices and asking whether the officer acted consistently or inconsistently with those generally accepted practices. There are a couple of things in that framework that I'm very careful, I'm very careful with all of it, but there are a couple of things that I'm particularly careful to avoid. It's not my role to determine credibility, whether someone is saying something honestly or deceptively. That is outside the scope of anything that I can do. But I do try and identify consistencies or inconsistencies between different pieces of evidence. So that's the overall framework. Is there anywhere in particular that you wanted me to start?
No. Up to you, Professor.
Okay. So the first, I suppose the first thing that, the first part of my conclusion in this case is the later statement by Officer Coy, now Mr. Coy, that he believed that Mr. Hill was engaged in a burglary or part of a burglary in progress at this residence. In my opinion, that conclusion is not consistent with generally accepted practices in policing. That is, the evidence does not sufficiently support that conclusion. I can dive into more detail
Yes,
and lay
please.
out the other. Okay. So reviewing the evidence, particularly from Mr. Coy's statement, we have the initial phone call from a complainant about what came in as a disturbance and what Officer Coy understood to be more of a suspicious person. The initial conclusion that Mr. Hill turning his vehicle on and off was probably an attempt to stay warm. A brief interaction where Mr. Hill apparently explained to Mr. Coy that showing him the cell phone and saying, I'm waiting for someone at this house or something like that. And then Mr. Coy returning to his vehicle and just sitting in there in case the caller came out or made additional contact, and just to sort of keep an eye on things. That's all pretty normal. That's a pretty normal interaction that really would strain credulity to say there might be a burglary in progress at this particular residence, in particular part because of how we know that residential burglaries usually occur. Typically, we have forced entry for residential burglaries. Typically, they're fairly fast. That is, typically, we don't have people actually go through and clear out an entire house of stuff. They grab small or high-value items, electronics, cash, medicines, jewelry. The idea of a lookout at a residential burglary is really more fiction than practice in policing. And we have that coupled with pretty straightforward explanation supported with at least some amount of visible evidence that I'm waiting for someone in that house. When Mr. Hill later entered the garage, again, that's pretty consistent with the explanation that he gave, that I'm waiting for someone in the house. I'm waiting for someone to make contact, or I think the text message might have said something like, you know, I'm.
Yeah, sustained as to what the text message said.
Oh,
Yeah, just don't say the contents of the text message, please.
yes, thank you. So we have behavior that is more consistent with perfectly innocent behavior than indicative of criminal behavior. Now, there are some indications of nervousness that Officer Coy's statement described, and nervousness is a relevant factor, right? As officers interact with someone, they certainly are aware of how that person is responding to them. But nervousness is a little bit tricky because officers also know that it's not unusual for someone to be nervous as they're interacting with an officer, and particularly when they're being asked to account for their behavior in some way, like, what are you doing here this evening, right? So although I certainly would not discount indicators of nervousness, it's also important to not, and this is common in policing, it's important to not exaggerate the relevance or salience of someone being nervous. When we get to the point where Mr. Hill has walked by Officer Coy's vehicle and
Professor?
I'm sorry.
I'm going to interrupt with a question that happened sequentially before that.
Sure.
Do you take any note of the fact that Mr. Coy never asked Mr. Hill for his name?
Yes, absolutely.
What of significance is that to you?
So anytime an officer is potentially investigating someone or engaged in what may be enforcement activity, it is certainly generally accepted in policing to try and identify that person. The failure to do so in an investigative or enforcement capacity is pretty significant. What that would tend to signify to me is either the officer is just acting inconsistently with generally accepted practices when it comes to engaging in basic investigative or enforcement activity, or the officer is not engaging in investigative or enforcement activity at the time. I have no way of determining which one of those things is true, but those are the two plausible conclusions.
What about the fact that the car was turning on and off for a couple of hours, being outside of the residence on Oberlin?
I have been in Ohio at about that time of year. I think that was pretty roundly dismissed by Mr. Coy at the time, as it looks like he's trying to stay warm in the vehicle from the statement.
Okay. What about the fact that Mr. Hill spoke to Mr. Coy as Coy is approaching the vehicle without being prompted, "Why are you here?" or things like that?
Again, when we have something that is entirely expected and normal, that's not an indicator of suspicion. When someone is wearing a heavy coat in warm weather, that stands out a little bit. When someone is wearing a heavy coat in cold weather, that's not unusual. We wouldn't expect that to signify anything other than normal behavior. So when it's clear that an officer is going to interact with you, it's not at all unusual for someone to preempt that initial communication or to make that initial communication by talking to the officer first. As I see an officer park and walk toward me, especially if I think, oh, I may be being asked to account for what I'm doing here, accounting for what I'm doing here doesn't strike anyone as suspicious, or at least should not strike anyone as suspicious.
Okay. Do you take any special note of the fact that the vehicle that Mr. Hill was driving moved from one location to another location prior to police officer arrival?
Not particularly. I don't know why that would or would not have occurred, but I don't think there's anything suspicious about moving a vehicle from one location to what may be a more convenient location, especially when you don't know what the parking situation was like when that vehicle initially got there.
Okay. Now, you, before I interrupted you, you were talking about Mr. Hill walking in front of Mr. Coy's vehicle.
Yes, and to the garage.
Okay. Did you take any exception to that or special note?
I would say that I certainly want to take note of everything that's happening, but I don't see any indicators of suspicion that you could say that walking to the house where you are apparently waiting for someone is indicative of some criminality, especially specifically indicative of being a burglary in progress.
Okay. Let's say we throw out burglary. What about any other aggravated felony or anything like that? Is it indicative of that type of item?
I couldn't see how. Just walking to a house where you said you're already waiting for someone, no.
Okay. Why don't you talk about the rest of the interaction and your thoughts and analysis of that?
Sure. So as a slightly separate, well, not slightly, as a separate opinion, let me clarify what I just mangled. The first opinion really relates to, could an officer applying generally accepted practices look at the situation and say, I think there's a burglary in progress? My conclusion is no, they cannot. The second opinion, which we touched on in that last conversation, is really about whether Mr. Coy acted consistently with the way that I would expect, applying generally accepted practices, an officer to respond in the event of a burglary in progress. That is, if we accept that this is a burglary in progress, or that the individual subjectively believes that this is a burglary in progress, are they responding appropriately, applying generally accepted practices in the manner in which they respond? And in this case, there are a number of factors that lead me to conclude no, that Mr. Coy's response, tactical decision-making, and approach are not consistent with generally accepted practices relating to a burglary in progress.
If an officer, according to generally accepted police practices, thought that a burglary was in progress, what would you expect to see?
First thing, and maybe most important thing, is communicating that to other officers, officers who are on scene verbally, or officers and dispatch via radio. Burglaries generally and burglaries in progress are kind of a big deal. They are they're potentially dangerous, potentially very dangerous situations. So you want to make sure that other officers on scene are fully informed, hey, I think this is what's going on, because that's going to dictate the response and tactics that the officers use. You want to make sure that your dispatcher is aware so that your dispatcher can give you and your radio traffic, anything that you transmit, the attention that it deserves. You want to make sure that your supervisor or other officers are aware, so if nothing else, they can start heading in that direction in the event that you need additional resources. With a burglary in progress, when we think that someone is in a house, we usually want to set a perimeter and start containing potential suspects. And that takes more than an officer, and often more than 2 officers, to do that effectively. So step 1, communicate your suspicions. I think this is what's going on, to your backup officers on scene and to your dispatcher and other officers via radio.
Okay. And you didn't find evidence of that here?
No, quite to the contrary. There's evidence that none of those suspicions were communicated to either Officer Detweiler or via radio.
Okay. Now, as Mr. Coy and Officer Detweiler approached the garage where Mr. Hill is located, what's your analysis with respect to that?
There too, the approach that Mr. Coy used at the time is not consistent with generally accepted practices in the context of a suspected burglary in progress. There are a range of tactical principles, guidelines, and practices that we expect officers to use. And tactics are really a way for officers to mitigate risk, to prevent risk from forming, and to prevent risk from ever becoming a threat. How close an officer stands to someone, the path that an officer uses to get to someone, whether an officer uses concepts like cover, which is a physical obstacle that will stop an attack from reaching an officer, or concealment, which is a physical obstacle that obscures the officer's location. I would expect in a dangerous situation like a burglary in progress, an officer to take advantage of core tactical principles like maintaining distance, using light to illuminate the situation and also to help obscure their own location. If you've ever looked into a flashlight at night, you know that it creates a bit of a difficulty looking past the flashlight. To use nearby vehicles or trees or the corners of houses to as obstacles, as either cover or concealment between you, the officer, and the subject whom you're interacting with the goal of ensuring that as you interact with that person, if that person does become violent or dangerous, you are in a tactically advantageous position. That is, the risk profile is reduced based on the officer's tactics. None of which happened in this case. Officer Coy approached from his vehicle, walked up the west end of the driveway past a tree that was there, and then just kind of up the middle of the driveway where there is no benefit of distance, there is no benefit of cover, there is no benefit of concealment.
With respect to Mr. Hill exiting the garage and Mr. Coy using deadly force, what's your analysis of that?
So the initial exit of the garage is, I think, not an indicator of suspicion at all, because it is apparently a response to the orders given by the officer. When an officer tells someone to do something and they do it, can't justify that or conclude that they're obeying an order like, hey, come here, exit the garage, is suspicious. There are a couple of specific factors in the statement that Officer Coy gave that Mr. Hill was raising his cell phone in a manner that was described as suspicious, that his right arm was obscured behind the car in the driveway, in the garage in a way that was described as suspicious. And looking at the totality of the circumstances, there are some problems with that characterization of that behavior as suspicious. One, we already have a display of the cell phone in the vehicle as indicator of, hey, I have a valid reason for being here. I am not aware of any actual case in which an offender engaged in some type of prestidigitation by luring an officer to look at one arm instead of looking at another arm. And in fact, officer training usually emphasizes being aware of an offender's hands because that's what hold weapons, right? That's what gets balled into fists or holds a knife or a gun or something like that. In my review of the body-worn camera footage, I did not see anything that looked consistent with intentionally obscuring the right arm, Mr. Hill's right arm behind the vehicle, so much as it was that he was just walking next to the vehicle where his arm happened to be obscured. There's a pretty significant difference between intentionally hiding something and like where my left arm is, you just can't see it because there's a desk and half wall in the way. All of this is sort of the overall context that gets us to the actual application of deadly force, which we can talk about. I think that answers the suspicion question.
Yes, yes.
Okay.
I do want to talk about, you started to go there, the application of the use of force, Professor.
Sure. So this is an officer-involved shooting. That's an application of deadly force. It's the clearest application of deadly force, and it's generally accepted in policing that deadly force is professionally appropriate only when the individual presents an imminent threat of death or great bodily harm. And again, that's ability, opportunity, and apparent intention to cause to cause great bodily injury or death. In this case, the evidence would certainly tend to suggest that Mr. Hill did not have the ability to cause serious bodily injury or death.
Overruled. The witness can answer the question.
Thank you, Your Honor. The evidence would tend to suggest that he did not have the ability and would not be reasonably perceived as having the ability or the intention to cause serious bodily injury or death. Note that's just two of the three components. I talked about ability and intention, which I'll get into in a second. Opportunity here, because of the proximity of Mr. Hill to the officer, they were within relatively short range and line of sight. There's no problem at all identifying that if there was a weapon, a firearm, that the officer, Mr. Coy, would have been vulnerable to being shot, right? So there was opportunity here, but for imminent threat, we require all three. So focusing on ability and intention are really the meat of my analysis in this case.
Okay. Can you talk about those?
Sure. So starting with ability, we talked earlier about there being an ambiguous situation, right? In not knowing exactly whether someone reaching into a pocket should be characterized in a non-threatening way or in a threatening way. And how context is really used to help develop that assessment, right? Is used to guide that conclusion. In the context of an interaction that's simply not particularly suspicious, right, of someone who is maybe a little unusually, but is just apparently trying to make contact with someone in a house, the context would not support interpreting an ambiguous situation in a way of, in a threatening manner. I want to contrast that because if you have a burglary in progress and you think you're interacting with a burglary suspect, that is dangerous, and that would tend to suggest that an ambiguous situation should be interpreted to say, okay, this ambiguous action, this movement, it is much more reasonable to view that as potentially threatening. In this case, in my opinion, that simply isn't justifiable, right? That is, the conclusion that this was a burglary in progress is not supported, and there's no indication from Mr. Coy's actions that would tend to suggest that conclusion, that contemporaneous conclusion at the time. So in the event of an ambiguous movement, like an arm movement, or an ambiguous object, like a shiny object in the hand, there's really no specific reason to say that is, my conclusion is that must be a gun, and that's indicative of the ability to cause a threat. Similarly with intention, when you have an individual, Mr. Hill, who has responded to the officer's initial inquiries, who has responded to the officer's continued inquiries by exiting the garage as he's being directed, by at least offering some explanation for his presence by raising up his hand, and who appears to be on camera moving consistently with normal walking movement, doesn't support the conclusion that this individual has the apparent intention to shoot and kill you as the officer. There's also a really important piece in this analysis. When I analyze a use of force case, what matters is the information that's available to the officer, that's reasonably available to the officer at the time. That is, we're very careful to not use information developed after the fact to and assume that the officer was aware of that, right? So a very simple example, if someone is holding a rigid, shiny object and making stabbing motions at an officer, it may be totally reasonable in the moment to conclude that's a knife and to react appropriately, even if you later find out that it's a harmless soft rubber toy or something like that. But there is one really important way in which facts developed after the fact can help us determine the reasonableness of an officer's perception, even though they were not specifically aware of those facts at all. That is, when an officer says, this is what happened, or this is what I concluded, when the facts don't support that action as happening, it at least calls into question the reasonableness of that perception. That's a little academic, so let me give you the simple example. If an officer says he reached for his waistband as if for a gun, and we later find out there was a gun in the waistband, that tends to support the reasonableness of the officer's perception that this guy was reaching for his waistband. At the same vein, if the officer says he was reaching for his waistband and I thought he was reaching for a gun, and there is nothing in the waistband, it tends to call into question the reasonableness of the officer's perception. Now, that doesn't mean it's dispositive. The individual might have been reaching into his waistband for some other reason or whatever, but it does at least call into question whether it was reasonable for the officer to perceive that. So in this case, when Officer Coy's statement indicates that Mr. Hill raised his right hand suddenly and aggressively, and although the officer may not have been aware of it at the time, we later know that he had keys in his hand, it would call into question whether whether Mr. Hill would have raised his keys to point as if it was a gun, because we know it wasn't a gun.
I want to back up a bit. I may have skipped over the part where Mr. Hill walks in front of the cruiser going up to the garage. What would you expect a reasonable officer to do in that circumstance if he felt that there was an aggravated felony happening?
Oh, I would expect him to immediately get on the radio to communicate that, and I would expect him to intervene to prevent that subject from going from an area that the police had access and some degree of control over, right outside the police vehicle, to an area where the police had very limited access and no control over, the inside of a garage.
Do you take any significance with respect to Mr. Coy saying to Mr. Hill, show yourself versus show me your hands? Or something more specific?
Only in the sense that if you are worried about something that someone might have in their hands, the generally accepted practice is for police to say, show me your hands, right? Or some equivalent of that. Again, I mentioned earlier, officers are trained to be aware of hands because hands are where threats are. So you want at least visual identification of where someone's hands are in the event that you think that it could be something dangerous that they may have,
Okay.
or that they present a danger, I should say.
Did you talk about, may have missed it, did you talk about all of the three components of threat in this situation of the time application of force was used?
I believe so.
He has. Asked and answered, right?
You've talked about that,
I
correct?
believe so, yes.
1 second.
Yes, sir.
Okay. Just make sure that it's clear. The witness did testify about ability, intention, and opportunity. I don't know about time. That's one thing where I'm a little confused. But if there is a question, ask the question. If there's an objection, make the objection, then the court will decide.
Thank you, Your Honor. Professor, at the time that the defendant used deadly force on Mr. Hill, were all those three elements present of a reasonable threat?
No.
Okay. Which ones were missing in your opinion?
At a minimum, intention, and I think the evidence indicates more strongly that ability is also missing.
And your opinion here, this is based on your training and experience as a use of force expert, correct?
Yes.
Thank you, Professor. I have no further questions.
Thank you, Mr. Pearson. Cross-examination?
May I proceed, Your Honor?
You may.
Thank you very much. May I inquire?
You may.
Thank you very much. Good morning, sir.
Morning.
We have not met yet. My name is Mark Collins, and myself and my partner represent Adam Coy. I believe you met Ms. Stevens before, correct?
Yes.
Okay. Thank you for being here. Sometimes I go too fast. If I do, please ask me to slow down and rephrase, and I'll be gladly to do that, okay?
Sure.
I want to start kind of at the beginning where you started and just clear some things up, if that's okay with you.
Sure.
So you were contacted in early 2021, correct?
I don't remember exactly when, but I know it was at least the first half of 2021, yes.
Okay. Do you know if you were contacted or retained? When was information sent to you?
Oh, I don't remember exactly when it was sent. I started my analysis of it in August, I believe,
Of 2020?
2021.
Okay, okay. All right. And thank you, I appreciate that. So you weren't provided any materials until after the indictment came back?
I do not know when the indictment is offhand, but I'm happy to accept your representation of that.
Yeah, account was in April of 2021 and February of 2021.
I didn't start doing my full review until then. I don't remember, again, when I was provided the materials.
I guess what I'm asking is, did you form an opinion before April of 2022?
Oh, April of 2022?
Excuse me, April of 2021, yes.
No, I had not done a full review of the file at that point.
I didn't ask if you did a full review, sir. I asked if you had done if you had information, decided to work with the government.
I had decided to work with the government, I believe at that point, but I had not formed opinions, having not done the actual review.
Well, you said initially that they give you a brief rundown and whether or not you can work with them, correct?
Whether the topic that they're asking me to work on is something that's within my area of expertise, yes.
And so that conversation occurred prior to the indictment.
I don't remember when. I'm not sure. I know it was the first half of 2021, but I don't remember when in there. I'd have to go back and look at my records.
And then with regards to your time for being paid, today is a standard 8-hour fee, correct?
It's 8 hours minimum. If I exceed the 8 hours between testimony and travel, then it's just hourly.
Okay, so even if we're done in 10 more minutes, you still bill for 8 plus the travel back, right?
No, I would bill 8. If testimony plus travel exceeds 8, I would bill more than 8. If it's under 8, which it won't be with travel back, then it would just be at 8.
So then yesterday you billed for that 8 hours as well, or however long it took you to get here,
Just travel, yes,
door to door.
yes.
Okay, and you mentioned you had been here prior to look at the scene. When was that, sir?
Yesterday.
Okay. So you had never gone to the scene prior to making your opinions or anything like that?
Correct.
You had been in Columbus prior to that, correct?
Yes, I had.
Multiple times, correct?
Yeah, I think I've been here 6 or 7 times now.
So no reason you couldn't have gone to the scene prior to writing your report, correct?
If I had been working on this case at the time of the trip, I think I've only been here once since I was retained in this case.
If I told you you've been here more than that, you would have no reason to disagree with me, correct? You testified in grand jury, correct? Since April of 2021, correct?
Yes, I'm trying to remember if that was remote or not.
You testified not once but twice in the grand jury, correct?
Yes, but I believe that was remote.
Okay. You came here for another case, correct?
Yes.
Okay. And so for you billed all your time. So it's not just the 37 or 38 hours, it's another 8 plus travel today, plus yesterday, plus all those other things, correct?
No other things, just yesterday and time today.
Other things being your flight cost,
Oh, sure, for reimbursement for costs, but not hours. Yes, absolutely.
your lodging, your food that you eat, all that's paid for by the government.
I don't bill or get reimbursement for food, but transportation, parking costs at the airport, hotel, that,
Absolutely.
yes.
Okay. And with regards to, let's talk about some general principles now, Mr. Stoughton.
Sure.
With regards to the Fourth Amendment, and I think you said it correctly, and I agree with you. I believe you would agree with me that all deadly force has to be analyzed using Fourth Amendment principles, correct?
No. It depends on context. So an agency, when they're analyzing use of force, is analyzing it under their administrative standard. They're not applying the Fourth Amendment because it's not a police agency's job to apply the Fourth Amendment in that way.
Why don't we give it some context now in our situation?
Sure.
Testifying and assessing criminal cases with regards to use of deadly force. We look to the Fourth Amendment, correct?
In Ohio, that's my understanding of Ohio law. In most states, no. They apply state law that is distinct.
We are in Ohio, correct?
Well, I hope so.
So why would you say not in Ohio? And I said, let's keep it to this context, we're in Ohio. We're in Ohio right now, correct?
I hope so.
You hope so. So why would you say, well, in Ohio, I believe so, but other states not?
Because your question was about whether we apply the Fourth Amendment in criminal cases, and the answer is it depends on the state. In Ohio, yes. In other states, no.
And you're testifying here in this state, so the answer would have been yes, here we do.
If I said yes, it would be an incomplete answer because it would indicate that we apply the Fourth Amendment in all criminal cases, and we don't. We do here in Ohio, so I understand state law, but that's not the case in most other states. So I'm just trying to provide a complete answer.
I appreciate your completeness, but I'd really like it if you just answered my questions, the specific question. Is that fine?
Sure, if you want to limit it to Ohio, I'm happy to apply that context.
Well, the ladies and gentlemen of the jury are limited to Ohio law, right?
Is there a question?
Are the ladies and gentlemen of the jury limited to Ohio laws? Mr.
Hold
Stoughton?
on. I'll sustain the objection. Okay.
You would agree with me that the Supreme Court emphasizes and outlines in these types of cases how officers are forced to make split-second judgments, correct?
Yes, that the evaluation should take into account that officers are forced to make split-second decisions, yes.
And again, I apologize, I answered with correct at the end. If you could give a yes or no, we'll get through this a lot quicker. Is that fair?
Sure, when it is possible for me to just flatly agree or disagree, I promise I will.
Absolutely. So circumstances can be tense, correct?
Yes,
Uncertain, correct?
sure,
Rapidly evolving, correct?
yes.
And you would agree with me in these types of cases here in Ohio, the situation must be evaluated from the perspective of a reasonable officer at the scene in his or her shoes, experiencing what that officer experienced, correct?
Yes, the objective, reasonable officer on the scene, absolutely.
And that is not could have, should have, would have analysis, correct?
I'm not sure what you mean by that.
Well, the analysis to be is the reasonable officer at the scene is what governs under Graham v. Connor for basic analysis, correct?
Yes, under the Fourth Amendment, yes.
Okay. And so in that situation, it's not hindsight or 20/20, that's strictly prohibited, correct?
Kind of.
In these cases in the analysis.
When you are talking about the prohibition on the 20/20 vision of hindsight, that refers to not using information that was only identified after the fact.
Correct.
That's the framework that we view the facts. That's different than the reasonable officer as an objective component.
Couldn't agree more.
Yes,
Okay. All right. And you would agree with me that officers are allowed to use deadly force if they're faced with an imminent fear of great bodily harm or death, correct?
imminent threat of great bodily harm or death, but yes,
Imminent threat, very well said. Okay.
yes.
And so if an officer perceives a deadly threat with a gun being leveled at them, he or she is allowed to respond with a deadly response, correct?
Assuming that perception is reasonable, yes.
Absolutely. Okay. And you would agree with me that law enforcement officers are trained on an action is faster than a reaction, correct?
That is a common and incomplete point in training, yes.
Once again, are they trained that an action beats a reaction?
I would say that they are trained that some actions are faster than some reactions. Yes.
And you indicated to Mr. Pearson on direct that officers are allowed to be mistaken about the perceived deadly threat, correct?
Sure, yeah, officers make mistakes.
And that has to be judged, that mistake has to be judged on reasonableness by the jury, correct?
Absolutely.
More likely than not is the standard in Ohio, correct?
I am not going to hold myself out as an expert on Ohio law, but I'm happy to accept your representation of it.
Okay, well, you're coming to testify in Ohio, correct?
Yes,
You testified before in Ohio, correct?
yes,
You're a law professor, correct?
I am.
My partner sent you State v. White at a prior date, correct?
Yes.
Okay. So is it fair to say that those are the aspects with regards to Ohio?
Objection, Your Honor.
Could you restate your question? Those are the aspects.
With regards to the jury has to decide what's reasonable or not with regards to a mistake.
Totally agree. To be clear, my reluctance to speak further on that was just with the more likely than not standard. I'm not familiar with that aspect of Ohio law
Okay.
enough as an expert to opine on it as an expert.
Well, you know the difference between beyond a reasonable doubt and clear and convincing, correct?
Yes,
You know the difference between clear and convincing and beyond a preponderance, correct?
yes.
And beyond a preponderance is more likely than not, correct?
Preponderance is more likely than not, yes.
So if the judge gave an instruction that they're to review the mistake more likely than not, you would be 100% agreement with that, correct?
It is the judge's job to instruct the jury on the law. I certainly am not going to second guess that. Yes, I would agree.
So you've never heard the term more likely than not, a jury has to resolve a mistake?
That's not what I said. What I said was I am not practicing as an attorney in Ohio or instructing the jury on Ohio law. So if you say this is the standards used in Ohio law, I will say, okay, but that's not my role as an expert to explain.
Absolutely. And you, I think, already indicated to Mr. Pearson on direct that officers are trained, they don't have to wait till force is actually used on them, correct?
Absolutely.
To respond.
Correct.
And there's actually a Supreme Court case that says, and officers don't have to wait till they see the glint of the steel to react, correct?
It communicates that meaning, yes. Officers do not have to wait until the shots are fired at them or the attack is in progress, just the imminent threat.
I asked you about the glint of steel. That's actually a quote in the Supreme Court case, correct?
Can you give me which case that is? I don't remember it from Tennessee v. Garner or Graham v. Connor or Scott v. Harris.
It's one of the three. It's in there. You'll take my word on that.
Sure, I'll have to go back and look at the language. I don't remember it in the majority opinion.
It was Justice Alito. Okay.
Writing in concurrence in Scott v. Harris?
You would agree with that concept, correct?
Sorry, which?
That an officer does not have to wait to see the glint of the steel or the force used upon them if they perceive a deadly threat to act on that deadly threat, correct?
Once there is an imminent threat, correct, officers do not have to wait for that threat to progress. Whether or not the threat exists at the time of glint of steel or before or after depends on the facts.
100%, okay. Now, part of your report that you rely upon, you prepared a report in this situation. Do you have that in front of you?
Yes, I do.
Okay. So you try to review all the information the best you can, correct?
Yes,
And I'm making an assumption here, I apologize, you do that probably at your office or home or wherever the best setting for you is, correct?
at home, yes.
Okay, when you have the ability, when you're ready to work on it, correct?
Yes,
Okay. And so you're trying to look at these facts and put these facts up to the, to the test to see, how they fit into your equation, correct?
yes,
Okay. And it's important that, you have facts correct in your report, correct?
it is. I want to have as accurate an understanding of the facts as I can.
Perfect. So you reviewed everything here, and then, so I'd like you to turn to page 14. At the second to bottom paragraph. Are you with me?
I am.
Now, the available evidence indicates that Officer Coy did ask Mr. Hill his name or for his identification, although he did run the license plate upon returning the police vehicle. Now, that's opposite of what you testified to, correct?
Yes, yeah, I think that's
You left a word out.
I did.
You left the word not out, correct?
Yeah, I sure did.
All right. So he did not ask, right?
That is my understanding, yes.
And that's your understanding. So I'm sure you read it, and you actually cited it to his statement at the bottom, correct?
Yes,
Okay, so that's a mistake by you, but you left a word out.
yes, that is one of several typos in this report, I'm afraid.
Okay, typo, so it's a typo.
Yes,
Okay, all right, and if you go to page, the next one is on page 27.
okay,
And on there, I'm sorry, because mine's double-sided. On there, that big paragraph, kind of second from the bottom, okay?
okay,
Officer Coy did not observe any movement in the house, and the fact that Mr. Hill had to knock on both the front and the garage doors, okay? So in there, you said Mr. Hill knocked on the front door and the garage door.
I believe that was Officer Coy's representation that he thought that that's what Mr. Hill was doing in the garage.
You reviewed his statement, correct?
Yes,
If I told you that that's not in his statement, nor his tape-recorded statement, or his testimony when he testified, would you disagree with me?
I am fairly sure that in Officer Hill's statement, there is some mention of thinking that he was going into the garage to a door.
So you're saying that you believe that he went in and knocked on a door? May I approach the witness?
No, I'm saying that yeah, if you have a copy of the statement, that would be great.
May I approach the witness?
You may.
May I? So specifically, you said in your report, he had to knock on both the front and garage doors. So you're getting that from somewhere, correct?
Okay, hold on.
I know he's reading, yeah.
Yeah,
I just wanted
either
to,
allow the witness to read the statement, or if there's a portion of the statement that you're aware of that you want to point out to the witness, please do that. But if not, just let them.
just giving him the context to look for.
Yeah, so the relevant part is on page 6 there. He was facing, sorry, this is Mr. Hill. He was facing the east wall of the garage, which is attached to the west side of the house, and I believe there was a door there that led from the garage into the house.
Nothing about knocking on that door?
No, just, yes, that's correct.
Nothing about knocking on both the front and the garage door, correct?
There's definitely a statement about him knocking on the front door. What I'm explaining in the paragraph of
Sir, if you don't mind, I'll ask the questions, okay? So in your report, you indicate that Officer Coy saw Mr. Hill knock on both the front and garage doors. That's incorrect. We can both agree on that, right?
The part of my report that you're talking about, that paragraph, is making the point that Mr. Hill did not have access to the house. that he could not just go into the house, either through the front door or through the garage door that Mr. Coy believed to occur. Yes, it is incorrect that he knocked on the door in the garage because there was no door in the garage. But the point of that paragraph is explaining that Mr. Hill didn't have access to the house.
I understand the point. You're saying there was no door in the garage? Just said, Mr. Stoughton?
I'm sorry, I'm confused about this, about what you're asking.
Madam Court Reporter, could you please read the question that I asked and the full answer that Mr. Stoughton gave?
In your report, you indicate that Officer Coy saw Mr. Hill knock on both the front and garage doors. That's incorrect. We can both agree on that, right? So part of my report that you're talking about, paragraph is making the point that Mr. Hill did not have access to the house, that he could not just go into the house either through the front door or through the garage door, that Mr. Coy believed to have occurred. Yes, it is incorrect. He knocked on the door in the garage because there was no door in the garage. The point of that paragraph is explaining that Mr. Hill didn't have access to the house.
Oh, okay, I think I understand your question now.
No, I'll rephrase the question. You testified right there that there was no door in the garage. If I may finish, in your report, you're saying that he knocked at both the front door and the door in the garage. None of that happened, correct, sir?
He knocked on the front door. That is, Officer Coy reported that Mr. Hill knocked on the front door, knocked hard on the front door. He reported that Mr. Hill went into the garage and was standing by, quote, I believe there was a door that led from the garage into the house. So to the extent that my report is describing that Mr. Hill had to knock on both doors, yes, you're correct. That is a misstatement on my part. There is no indication that he had to knock on any garage door.
So
For my purposes, the presence or absence of a garage door is really irrelevant. The idea is that Mr. Hill did not have access to the house, which undermines Officer Coy's statement that he was involved in a burglary at that house.
you just testified that there is a door that leads out there. So he does have access, correct?
Well, no, he wasn't in the house. Is the whole point of that paragraph is explaining that he did.
I understand the issue.
Not that he couldn't get into the house and that there's no way to get in the house, but that he wasn't in the house.
Mr. Stoughton, do you realize that the definition of burglary in the state of Ohio includes a garage?
Sure.
So you can have a burglary in a garage, correct?
Sure.
Okay, all right, just making sure. So when we talk about access to a house and stuff, you can burglarize a garage, correct?
Sure.
Okay. Now, you mentioned about secure points of entry. You don't know how many points of entry at that house, do you?
Do you mean like windows and access points?
No, I mean, you're saying that those in your, let's go through page 27, all right? Suggested, so the garage doors suggested that these points of entry at least were secure. So you have no way of knowing if the garage door was secure, correct?
What I know,
It's a yes or no answer, sir.
yes, I think based on the evidence, yes, we do know that because Mr. Hill wasn't in the house, he was in the garage.
The word secure means that the door is locked, correct? Because he was knocking on the door and nothing happened, that it was secure. It was closed, shut, you couldn't get in, correct? That's when you use the word secure.
It was certainly closed and shut and he did not get in.
Okay.
John, may we approach?
All right, excuse us a moment, ladies and gentlemen. Overruled.
Thank you, Your Honor.
Let me ask the question.
The report is incorrect, correct, with regards to that aspect of knocking on the door and the inside of the garage.
Yes, sure.
Okay. On the same page, you had testified to Mr. Pearson that, burglaries that happen at certain times normally involve electronics and medication, correct?
The most common items stolen during burglaries.
Okay. And I think you say that in the middle of that paragraph, often currency, electronics, firearms, gold, jewelry, medication, correct?
Yes,
Okay. You reviewed the photos of what was inside the car, correct?
yes.
Were you aware that there was medication in a different person's name laying out in the car?
I'm sure I was if that was in the photos or identified in the property receipts, but since the officer couldn't identify anything that was in the car,
Sir-
that's irrelevant for my analysis.
You put in your report, sir, that burglaries often involve medications and electronics, correct?
Yes,
In this case, there's an electronic in the car based on the pictures, correct? A phone, correct?
in Mr. Hill's vehicle?
Yes.
Not that the officer was aware of, which is the operative facts. That would be the 20/20 vision of hindsight that we were talking about earlier.
A yes or no question. In the crime scene photos, is there electronics in the car?
Yes.
Is there medication based on someone else's name in the car?
Again, I will accept your representation and say yes, I don't remember offhand.
May I have the envelope, Your Honor? Does that refresh your recollection, sir?
It does, thank you.
So you didn't put that in your report, correct? Thank you, Your Honor, I'm sorry.
I did not. My report is focused on the information available to the reasonable officer at the time, and that was not.
Now, you said on direct, and I believe also you say on page 36 of your report, that it was clear that Mr. Hill was carrying a set of keys, correct?
No, I don't believe I did. I said after the fact, it's clear that he had a set of keys, but at the time, no, that's not my testimony.
My question was, you told Mr. Pearson on direct that it was clear after the fact he had a set of keys,
Yes.
correct? Okay.
Yes, I agree with
In
that.
his hand at the time?
It was clear after the fact that at the time he had a set of keys in his hand, yes.
Okay. And those keys are silver, correct?
There was some silver, there was some black, there was a little tag from a grocery store thing that was yellow, I think. There were some car keys, yeah.
Made of metal, correct?
Yes.
Predominantly silver, predominantly metal, correct?
Yeah, silver, black, and some other colors, yes.
I asked if it was predominantly silver, sir.
I didn't really measure out whether it was predominantly black from the base of the keys and the car keys, or whether it was the metal part of the keys were silver, yes.
Did you look at the actual keys and hold them in your hands?
Yes.
Okay. So you saw that the predominant color is silver, correct?
Of the keys, yes.
Of the entire concept, right? There are some dashes of other colors, but the dominant color is silver of the majority of that.
Sure, not including the car key base, which was not part of the evidence, but yes.
Now, you talked on direct that you didn't feel, and in your report, again on page 30, the top of page 30, I'll direct you, with regards to the communication by Officer Coy to Officer Detweiler, correct?
Yes.
Okay, do you know how long they've worked together?
No.
Do you know how many runs they've been on together?
No.
So if Officer Detweiler were called, was testified here and said, once he said, no, something's weird, she knew there was a duty to investigate. You would disagree with that?
No, I wouldn't disagree with that. That's very different than saying I think there's a burglary in progress.
Okay. You keep saying a burglary in progress, correct?
Yes.
Okay. Reasonable suspicion is a duty to investigate, correct?
No, reasonable suspicion is a quantum of proof, like preponderance of the evidence in a particular thing.
In a particular thing, officers have a duty to investigate if they believe there's reasonable suspicion of something going on, correct?
Are you asking about a legal duty? Because no, they don't.
No, the duty so that they can have an encounter. In order to stop someone to talk to them, to investigate, they have to have a reasonable suspicion.
Yes.
Correct, okay.
Yes, I agree with that. As a threshold for detaining someone, yes.
Threshold for detaining something.
Sure.
They have to have a reasonable suspicion, correct? Okay. So, and sometimes in officers' reasonable suspicion, they're mistaken, correct?
Oh, yeah, absolutely.
Turns out to be nothing.
Sure.
Sometimes it turns out to be something.
Yes.
Sometimes it turns out to be that you need to investigate more, correct?
Yeah, absolutely.
So when you reviewed Officer Coy's statement and what he said in his interview, he indicated a lot of things were going through his mind about reasonable suspicion, correct?
We could look at his statement again, but yes, he certainly had a bunch of factors that he listed.
Correct. It could be a burglary going on, correct? Potentially, that's what he says.
Yeah, that is the predominant thrust, yes.
Could be someone, trespassing, could be someone out back handing stuff out, he said, correct?
I understand that to be part of the burglary, but yes.
Okay, so it wasn't, no, there was definitely a burglary in progress going on. He never said that, correct? You're using the term a burglary in progress. He never said, I have reasonable suspicion because there was definitely a burglary in progress going on.
Well, that wouldn't make sense, right? Because you couldn't say I have reasonable suspicion because definitely. Reasonable suspicion is an amount of belief, an amount of suspicion. So what I understand him to be saying is I had reasonable suspicion that there was a burglary in progress, not reasonable suspicion that it was definitely occurring.
He indicated to the ladies and gentlemen of the jury, they had reasonable suspicion to investigate and make contact. You agree with that, correct?
I think that conflates the legal standard and an officer's duty. Reasonable suspicion is a degree of proof that justifies an officer in, for example, detaining someone.
Correct.
You can't have reasonable suspicion in detaining someone. You can't have reasonable suspicion in investigating. You have to have reasonable suspicion of some criminal activity to investigate someone.
Hypothetically, Mr. Stoughton, if you have a dark garage, you're not sure if the person's supposed to be there, and you see him hidden down in the back, you have a reasonable suspicion that something might be going on, correct?
You might suspect something. Whether or not that's a reasonable suspicion of a crime, which is what the legal standard is depends on the facts.
Absolutely. But that hypothetical, the officer has the ability to go forward and contact that person and investigate, correct?
Under either of two ways. One, the officer might have reasonable suspicion that justifies a detention, but you can also ask someone to just comply. You can have what's called a consensual encounter where you don't even need reasonable suspicion. You're just asking for the person to voluntarily agree with you.
And earlier, there was a consensual conversation, correct? Both at the car, right?
Sure.
And there was a consensual request by my client, hey, what's going on? And he got no answer at that point, correct?
At which point, sorry?
When Mr. Hill was heading back.
So I understand his statement, yes.
Yeah. So he went to have another consensual one. There was no answer, correct?
Well, I'm sorry, are you saying that when he approached the garage, that's a consensual encounter or that's a reasonable suspicion stop?
Mr. Stoughton, when my client said, hey, what's going on? What are you doing? There was no response, correct? By
Yes,
Mr. Hill.
as he was walking by, yes,
Okay. Mr. Hill doesn't have to respond. He's
Yeah.
under no lawful duty to respond.
correct.
Okay. But that was an attempt at a consensual contact, correct? By my client.
I don't know what was in your client's head and whether he thought he had reasonable suspicion, but I would certainly say that was at best a consensual encounter because there was no reasonable suspicion of a crime.
At that point, it's an attempt to have a consensual encounter by my client, correct?
Sure,
Right. And it wasn't answered, correct?
yes.
So again, if Officer Detweiler testified that she had reasonable suspicion to investigate based on what was told to her and based on what she observed, and she drew out her weapon low and ready, you wouldn't disagree with that, correct? In her mind, she formed the opinion that something was going on.
Reasonable suspicion of what?
Something criminal afoot, something going on they have to investigate, sir.
Sure, she could think that there was reasonable suspicion, I guess. Yeah, I'm not privy to her testimony, but if she testified that, I would have no reason to disagree that she thought she had reasonable suspicion.
Okay. But you only have you have a difference that my client didn't have a reasonable suspicion to investigate and contact and move forward, correct?
My testimony and opinion is that there's no reasonable suspicion to believe that this was a burglary in progress. That there was any sort of, as I testified on direct, that there was any sort of aggravated felony situation here.
Didn't ask about an aggravated felony or a burglary. I asked if he had a reasonable suspicion to move forward.
Not that I have seen articulated as reasonable suspicion of a crime, particularly of the type of crime that he specifically identified.
Okay. He identified multiple crimes, correct?
I, I, I believe the focus is on burglary in progress.
Your burglary in progress, that's a term that you used. There's never I'll move on. Mr. Stoughton, let's talk about.
Sorry, on page 6 of
Mr.
his
Stoughton,
report.
I get to ask the questions here.
I'm sorry, I was just trying to answer them.
That's okay. So with regards to the law that the jury receives, you agree with me that that comes from Judge McIntosh?
100%, yes, absolutely.
And you don't need to be an attorney to apply those laws for everyday jurors, correct?
Yes, that's correct.
Now, let's talk about your training as a police officer and your use of force.
Sure.
Okay. My understanding is you were an officer for about 5.5 years?
Yes, a little under 5 years full-time and then another 6 months part-time, yes.
Part-time is auxiliary or?
We called it reserve, but same idea.
Okay, okay. And it appears as though you had about 4 hours of use of force training when you were a police officer.
Oh, no, that's wildly wrong.
Okay. Well, I thought so. So I got your records from your training and stuff. So if they were to say something different, you would disagree with those records?
Yeah, we had 8 hours of in-service defensive tactics training every year. We had another 8 hours of firearms training every year. That's 16 hours of training every year just on the particulars of use of force, not including academy or pre-service training.
Anytime you do, I didn't ask about academy or pre-service, I asked about on the job. But anytime you did any type of training, you had to sign in, right?
I don't remember. It's been almost 20 years.
Chairman, we approach.
All right. Yes, you may inquire. If it's marked for identification purposes,
Only, yes, only for identification purposes. May I approach a witness?
you may.
I'm handing you, Mr. Stoughton, what's been identified as Defendant's Exhibit 13 for identification purposes. Did you take a look at that?
Sure.
And I guess my first question is, do you recognize your name and signature?
Yeah, my name is right here. It is unsigned, just my name.
Your name is there. Do you recognize that as a Tallahassee, field training and evaluation program?
Yes, this is when I was in field training, part of the pre-service training.
Okay, so you recognize or you understand what that is, correct?
Yes.
Okay. You participated in that, correct?
Yeah, looks like.
Okay. And again, for the next page, the title of that one.
On the top, it's Tallahassee Police Department Field Training and Evaluation Program, student roster. This is again part of the pre-service training.
Is your name on there?
Yes,
And your handwriting?
yes.
The next page.
Same thing, it's field training and evaluation program. This one for legal updates. Again, this is pre-service training before I was in a patrol car.
And you may continue.
This is Tallahassee Police Department Training Section Attendance Roster, law enforcement response to a WMD incident, that's weapons of mass destruction incident. This is December of '01, so this is post-field training.
And you may continue. Why don't you take a look at them and make sure that you know what those are and recognize that, correct?
Sure.
Let me know when you've done that. You recognize what they are, correct?
I do, yes. They're largely training rosters with some evaluations from kind of all,
Different times when you were involved with the police force there, correct?
yeah, different trainings.
If you'll go back to the front page, sir.
Sure.
And the topic on that front one is use of force, correct?
Defensive tactics, use of force, yes.
The amount of hours is 4 hours, correct?
Yes, that's correct.
Nowhere else in that pile of information with regards to where you're signed in, is there anything else with regards to use of force training, correct?
This is sort of an obviously incomplete training record.
I-
And yes, I think there's in-service defensive tactics training in '04. There's spear and defensive tactics training in '02. I don't see some of the stuff like fingerprint training that I went through.
Sure.
Yeah, in-service training in '02 on defensive tactics, use of force. So no, that's not the only use of force training.
Understood, understood. So with regards, now, were you ever, as a police officer there, part of the officer support?
I'm sorry.
When you were a police officer there, were you ever part of the officer support team?
No, we didn't have quite that parallel, but no.
All right. You understand why it is and the need for it, correct?
Oh, yeah, absolutely.
Everybody reacts differently after they're involved, and whether they come to a scene that's horrific or they come to involved in a shooting at them or somebody else, correct?
Sure,
Okay, human nature, correct?
sure.
Now, Mr. Stone, I'll help you with that. That's just what was sent to us. I agree with you, there may be more that we don't have, correct?
Yes, I'm just in flipping through, there's use of force training in '02, '03, '04. So it's not just that face sheet.
Understood, but it's at a 4-hour increment each year, at most.
I wasn't looking at the hours. Actually, a lot of them don't even identify the hours, it's just the login date. But it's usually, it was usually an 8-hour training.
Whereas the first one was a 4-hour training.
Yeah, that's the pre-service training, so that's just post-academy before field training.
I want to switch gears a little bit, Mr. Stoughton. Recently, you've been involved in some case, well, recently you were involved in a case in which you opined that the officer's belief that there was an imminent threat was unreasonable in January, or this year, January of 2024. Do you remember that?
Sure.
Okay. Specifically, you were involved in the case of, all right. Do you remember working on the case? Gibb versus Webb.
Oh, Gibb,
Gibb
yeah,
versus
that's one out of the Dakotas, right?
That was in North Dakota, a
Yeah.
federal case.
Yes,
You were retained by the plaintiffs, correct? You issued a report.
yes.
And you indicated that that the officer's reasonable belief of an imminent threat was unreasonable and therefore it was excessive force, correct?
I haven't looked at that one in a while. I'd have to go back and look at my report to figure out exactly what my opinion was. It was definitely I think at the point of,
Sir,
there were different opinions in that case. If you have it, I'd love to see it.
absolutely, sir, you didn't include that in your CV, did you?
Oh, I thought I had.
If you'll check your CV for that.
I do not have my CV, but if you say that it is absent, I will believe you.
So in there, do you remember reviewing, that was dismissed on summary judgment, correct?
I have no idea.
Do you remember the court saying that Stoughton's opinion does not coincide with the law?
No, I don't. I give my opinion in reports and don't really, if the attorney shares something with me, I'll review it, but otherwise, my job in the case is done.
Objection, Your Honor.
All right. Again, excuse us, ladies and gentlemen. Counsel, please approach. Okay, ladies and gentlemen, we're going to try to take just about a 5-minute break at this point in time. If I can get you back in the jury room at 12:20. 12:20. Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury. Thank you, ladies and gentlemen. We're going to take about 5 minutes. Don't you think we've all, that's yours ready? Okay. Okay, all right. Right, if you get the jurors, Ms. Harper.
Here's a list of all the third person parkways that occurred. And that's pulled from publicly available information on the CPD website that anybody can go for. Grab.
Sure.
Yes.
Additional matter.
On the record? Yes. Could you stop, Ms. Harper? All rise for the jury. May be seated, ladies and gentlemen. Just so the record's clear, the initial objection is sustained.
Thank you, Your Honor.
You may inquire. You may.
Thank you so much. Mr. Stoughton, just a couple more topics.
Sure.
Get through this. You were never trained to be a police officer in Ohio, correct?
Correct.
Never OPATA certified?
Correct.
Never trained officers in Ohio with regards to use of force training, with regards to OPATA standards?
Correct.
And in your report, Mr. Stoughton, on page 26, and I think you talked about it with Mr. Pearson on direct, and now I'll get you to there. It's a well-known policing that most residential burglaries occur during the day when the occupants of the home are less likely to be present, okay? And you mentioned that this started around 1:30 a.m., correct?
Yes, I'm looking for that spot in the report, but yes, there it is, yep.
Bottom paragraph, yeah. So, and again, you're relying on national standards, correct? Or national studies?
Yes.
Okay. So you didn't, Columbus has a website that has a public record of reports or runs on burglaries or thefts. Were you aware of that?
I think I was aware that it existed, but but not more than that.
So you didn't go and analyze and look at a time frame with regards to this area or anything like that?
No, I did not.
Okay. And you would agree with me that officers who patrol that area would know and have better experience or with regards to when property or burglary crimes are higher or lower depending on the times of the year? You would agree with that, correct?
I would hope so, yes.
Absolutely. And so with regards, if I told you that I've shared this, if I've told you that within 12 days prior to December 22nd of 2020, that there were 8 burglary property thefts runs, and 6 of them were between the hours of 11 p.m. and 5 a.m., and only 2 were during the daylight, would you have any reason to disagree with that?
No, I would have no basis to disagree.
That's a situation where the local situation does not conform to the national standard that you list in your report.
I would need to delve into the data to define that, but sure, maybe.
Okay, all right, all right. Now, you agree with me that an officer can be mistaken if they see a deadly threat, correct? And they react to a deadly threat?
That can be a mistake, sure, yes.
Absolutely, okay. And believing that you see in a silver revolver could be a deadly threat, correct?
I'm sorry, are you asking whether that can be a mistake or whether seeing a revolver can be a deadly threat?
Both. If you see a revolver, that's a deadly threat.
It can be, it isn't necessarily. People can lawfully carry or even hold weapons while interacting with officers, but it certainly can create a deadly threat situation, sure.
Let's just get right to the point. I'm not talking about all those other things. Just if an arm's coming up and an officer sees a gun, that's a deadly threat, correct?
Yes, I think it is reasonable to conclude that, yes.
Gun could be on safety, correct?
Sure, could be.
Gun could be unloaded, correct?
Yeah, sure.
Gun could be can't work.
Yeah, could be fake, sure.
But, so, and the person who had that gun might know that, correct?
Yes,
But the officer would never know that, correct?
absolutely.
Now, same thing, that's an actual threat. With regards to a perceived threat, if an officer perceives a deadly threat and believes there to be a silver revolver in the hand, that could be reasonable in certain contexts or situations depending on the facts, correct?
It absolutely can be reasonable, yes.
And then on page 40 of your report, you kind of go through that process on the second to last paragraph,
Yes,
assuming for purposes of analysis that a reasonable officer in Officer Coy's position could have reasonably mistaken Mr. Hill's keys for a firearm, then a reasonable officer could have concluded that he had the ability to cause the death or great bodily harm, correct?
absolutely.
And you believe that that's the job of the jury to determine whether or not that mistake was more likely than not,
I do, yes.
more likely than not reasonable.
Whether it was reasonable, yes, correct.
Thank you. Mr. Stoughton, that's all the time I have, or the questions I have for you. Thank you very much.
Thank you.
Thank you, Mr. Collins. Redirect.
Thank you, Your Honor. I will work backwards. I believe the last exchange of questions with Mr. Collins boiled down to anytime an officer sees a gun raised at them, it would be reasonable to interpret that as a threat, correct?
I think that's a little bit of an overstatement, but in the field type situation, yes, if an officer sees someone who is actively raising a gun to point it at them, I think it's reasonable to conclude that that's a threat.
Would it also be true to say anytime an officer sees an individual with the gun, not raised at them, but with a gun, it would be reasonable to perceive that as a threat?
No. No, there are other officers have guns. People can lawfully carry guns. They can lawfully handle guns in front of officers without necessarily creating a threat.
Okay. So is it your testimony today that it depends on context?
Depends on context, yes.
And as was pointed out in your report, in that second to last paragraph on page 40, there's a lot of, I mean, there's a could there in italics. Does that need further explanation? Or I guess, can you explain that a little bit further?
Sure. So as I think I indicated, there's no objective identifiable evidence as to what the keys looked like in Mr. Hill's hand. It's not on camera. There is no, other than Officer Coy's description, there is no basis for saying this is what they look like or did not look like. This is what they reasonably could have been mistaken for or not reasonably mistaken for. So that paragraph that that was read in Cross follows a paragraph that talks about assuming for the sake of argument that an officer could not have reasonably mistaken the keys for a weapon. There is insufficient information in the record for me to say whether to say what the keys look like or whether it was reasonable just on that basis to conclude that the keys looked like a weapon or did not look like a weapon. As we talked about before, I think there's a substantial amount of evidence in the record about the context that would lead me to conclude that one should not assume, right, in an ambiguous situation, the context does not support the conclusion that that Mr. Hill was holding a weapon. But that's different than what did the keys actually look like, and I don't know. Ultimately, that's a factual determination that is outside the scope of expert testimony that you guys get to make.
With respect to threat, to me, and correct me if I'm wrong, that particular point only relates to ability. Is that correct?
That's correct, yes.
And how with the other two items?
So again, imminent threat has those three components: ability, opportunity, and intention. When we're talking about what the keys looked like and whether they could be reasonably mistaken to be a firearm or not, that's only relevant to ability. That is, did Mr. Hill have, or was he reasonably perceived as having, the physical capacity to shoot the officers? That's separate than opportunity, which we've talked about, and it's separate than intention, which we've also talked about.
Now, you base your analysis within this whole thing on viewing the body-worn camera of the defendant, correct?
And the other evidence, but yes, heavily on the body-worn camera, sure.
Okay. And do you see any evidence on the body-worn camera of silver or anything like that?
No.
Okay. Do you see any evidence of Mr. Hill blading or anything like that?
No, my assessment of Mr. Hill's actions in the body-worn camera.
Judge, at this point, outside the scope of Cross, that was never gone into my Cross.
I'll allow that question, but we won't go down that road too far.
Thank you, Your Honor. Can you describe his actions as he's walking out of the garage?
It looked like he was walking fairly normally.
Mr. Collins asked you a little bit about action versus reaction, and it sounded as if you wanted to, categorize your answers. Can you talk about that a little bit more?
The action-reaction focus is the very intuitive idea that if you're trying to catch up with someone, they are going to move before you, right? And it is a very intuitive idea, but it's not very well defined and it's not very well supported in actual empirical science. The studies, and I'm using that term very loosely, that support it are pretty deeply methodologically flawed. And there are lots of situations where action, in fact, does not beat reaction. If you think about your, playing a childhood game of slaps, right? There are plenty of situations where whoever is reacting to the person's first movement can actually react before the person gets the slap in or something like that. So while there are certainly situations where someone's action will preempt someone's reaction, that's really simplistic and not very useful in thinking about actual human dynamics and interactions.
All right. My next question relates to the medications that were in Mr. Hill's vehicle that he was driving at the time. Why is that relevant or not relevant to your analysis of this case?
It's not relevant to my analysis because the factual framework, that is the way that I look at the facts, are the facts that were available to the reasonable officer at the time. And Officer Coy's statement indicates that he could not identify or see what was in Mr. Hill's vehicle. So if he didn't know that there were medications or electronics or anything else, a bazooka, right, in the vehicle, then it's irrelevant because he just didn't have that information at the time. When we talk about not relying on the 20/20 vision of hindsight, that's exactly what we're talking about, not imputing to the officer information that they could not have possibly known at the time, whether that's to the officer's detriment or benefit. Either way, they don't get to use it.
With respect to those training records that you were shown by Mr. Collins, is it your testimony today that those are not your complete training records from Florida?
They are not complete. It doesn't have everything, and there are also defensive tactics and use of force training at least every year and additional training beyond the in-service training. I can go through them if you'd like.
Please don't. But outside of those, you have had lots of training with respect to defensive tactics and use of force, right?
Yes, outside of that training, both as an officer and certainly having provided that training after being an officer, yes.
Do local officers have to abide by generally recognized police practices, or are they supposed to comport to their local practices?
Ben, Your Honor. Outside, and I'm not sure where that's going with regards.
Sustained.
May I approach, Your Honor, with respect to Mr. Coy's statement?
Good.
You may.
Yeah, mine's on the stand. Thank you. May I approach, Your Honor?
You may.
I've had two items. First, with respect to that first item, that would be the defendant's written statement that he provided.
Yes,
PCI, correct?
yes.
There's a paragraph that I have set out that discusses his response, or I guess his take on what he thought was happening, correct?
Yes.
Can you read that, please?
It starts on page 5 with a list of factors. Do you just want me to start with the
Yes.
relevant part on page 6? The sentence continues, he knocked hard on the door of the house with no response, made me begin to think that a burglary in progress may be occurring.
This other item is his transcript of his interview with PCI, correct?
Yes, it is.
Okay, can you read the portion that I highlighted there?
This is Mr. Coy speaking, quote, then the ignoring them, then the knocks on the door when someone was supposed to be there, everything just started to click together. And at this point, I'm thinking, did he go around the back of the house? So without discussing to her, we start to take a couple steps forward, and that's when I start scanning with my light. And it's starting to process now with everything that's going on as we take those first couple steps. something else is going on. There's a burglary, there's a burglary going on. He's trying to warn somebody in the house. They got somebody being held in the house. Everything started to come together that I needed to investigate further.
Would it be within generally recognized police practices for an officer to expect a burglar to knock on a door of a house that they're trying to burglarize?
No.
Have a quick moment, Your Honor.
You may.
And Mr. Stoughton, is it your opinion that the defendant operated outside of generally accepted police practices when he shot and killed Andre Hill on December 22nd, 2020?
Hold on.
Objection, Your Honor.
Okay. Overruled.
Thank you, Your Honor. No further questions.
Oh, I answer the question.
I'm sorry.
Yes.
Thank you.
Thank you, Mr. Pearson. Recross?
Briefly, Your Honor, may I proceed?
You may.
Mr. Stoughton, my client's under no obligation to give a written statement, correct?
Yes.
My client's under no obligation to give a taped statement with agents hours long, correct?
Yes, in this context, yes.
My client's in no obligation to take the stand in this case, correct?
Sure, correct.
Now, back to the report, let's go back to page 5 on the witness statement. Do you still have that up there?
I do not.
May I proceed?
You may.
I'm handing you the statement.
Thank you.
Go to the bottom of page 5, sir.
Okay.
If you read for the ladies of the jury where it says, "At this point."
At this point, I was concerned that there was something more going on and that he was not just waiting on someone to come out.
Okay, so right there, at this point in time, I'm concerned that there's something more going on, correct?
Yes,
Someone's not coming out, correct?
yes.
Keep going, sir.
The fact that he had previously been parked a few houses down, parentheses, east, to where he was presently parked, the fact that he had a text up on his phone ready to show me before I ever asked a question began to seem like it may have been a pre-planned story. The fact that he was dismissive of me and wanted our interaction over quickly and appeared to be trying to block my view into his SUV, the fact that he kept his eye focus on me while walking down the sidewalk, ignored me the second time he walked by me when I asked what was going on, and the fact that he was allegedly waiting on someone who was supposed to be coming out, but no one had come out, and he knocked hard on the door of the house with no response, made me begin to think that a burglary in progress may be occurring.
May be occurring, correct?
Yes,
I thought there was a possibility someone else, an accomplice, could be inside, is the next sentence, correct?
I thought there was I thought there was possibly someone else, parentheses, an accomplice, inside the residence of the address.
So given the totality of the circumstances, he's explaining that he had then, if you'll read the last line of that paragraph.
Given the totality of these circumstances, I had a duty to investigate further and decided to go around to the back of the house.
So all those things are going through the catalog, all those things are going through his mind, and then he's telling you the context, so I have a duty to go back around the house. So that was his intention right there, correct?
It's certainly what he's expressing in his statement. I don't want to say I knew his intention at the time.
Well, part of intention is reading what someone says, correct? Someone
Sure,
else.
I can tell you, like, he says, this is what I was doing, right? But
That's more helpful than reading someone's mind, correct?
I try not to do that.
More helpful than reading someone's actions, correct?
Often not. Often actions speak louder than words.
Absolutely. So an action of lifting a hand up with a perceived deadly weapon, it speaks louder than the person saying, hey, I'm not doing anything, nothing's going on here, correct?
If you reasonably perceive it as a weapon, sure.
Absolutely. And so, in regards to that situation, so with regards to there, I have a duty to further investigate, and I say to go around to the back of the house. So he's going around the back of the house to continue his investigation at that point, correct?
So he says. He obviously did not go around the back of the house, but yes.
Because he saw someone hiding in the back of a garage, a dark lit garage, an open garage at 2 a.m. in the morning, correct?
I don't believe he indicated that anyone was hiding in the garage, no.
So if he told the ladies and gentlemen of the jury that in his testimonial statements, you would disagree with that?
I don't know what he testified to. In his statement, he does not describe Mr. Hill as hiding in the garage.
So someone in the way back of a garage, crouched down, could be reasonably interpreted as hiding in the back of a garage, correct?
Again, there's nothing in the statement, which is the only evidence that I have about crouching, but sure, yes, it could be.
And especially after they just walked away from an officer, and didn't respond to the officer, correct?
Sure.
May I have a moment, Your Honor?
You may.
Mr. Stoughton, I apologize, that's all the questions I have.
Thank you.
Follow up, Your Honor.
Yes.
Thank you. Cross or recross. You don't judge the credibility of statements by the defendant when you wrote your report, is that correct?
No, I do not.
You just looked at whether his statements were consistent or not consistent with what you expected, correct?
Correct.
And his actions, according to you, I believe according to what you testified, are not consistent with a reasonable officer on the scene at this time thinking a burglary is in progress. Is that accurate?
Correct.
Thank you. I have no further questions, Your Honor.
Thank you. Mr. Collins? All right, okay. You can step down at this time.
Thank you, Your Honor.
All right, ladies and gentlemen, we're going to go ahead and break for lunch at this time. Lunch is going to be a little bit longer just because the attorneys and I have some legal issues that we're going to need to deal with before we can move to the next portion of the trial. Just want to make sure, anything else on behalf of the state?
Nothing from the state, Your Honor.
Okay. Anything else on behalf of the defendant?
No, Your Honor.
All right, thank you. All right. So if we get you back in the jury room at 2:15, okay, 2:15. Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury.